Imagine a scenario in which you could get someone to plead guilty willingly to a crime that they didn't commit. Unfortunately, this happens to a disgracefully large number of people each year in the US. The circumstance can largely be attributed to rampant overuse of plea bargaining within the US judicial system. According to the National Association of Criminal Defense Lawyers, with more than 97% of criminal cases being resolved by plea bargain in a constitutional system predicated upon the Sixth Amendment right to a trial, the fact of imbalance and injustice in the system is self-evident. Although initially the practice of plea bargaining was well-intended, with the soaring number of criminal cases on the dockets of the U.S. courts, today plea bargaining is essentially a thimble being used to bail out the Titanic. That's why today I'll be talking about the unintended consequences of plea bargaining, its prolific misuse in place of a jury trial, which results in not only a moral dilemma, but the loss of our inherent Sixth Amendment right to take cases to trial. Roughly 80,000 federal court cases are filed annually, yet surprisingly, the largest percent of these will never make it to trial. According to sources like the Innocent Project and the National Association of Criminal Defense Lawyers, 97% of defendants charged with a federal crime choose to waive their right to trial by jury and accept plea bargain offers. And perhaps even more surprising is the fact that this statistic has remained stagnant over the last 50 years. In essence, plea bargaining has become the backbone of our U.S. court system. So, what's the driving force behind these numbers, and why would innocent people waive their right to a trial by jury and instead plead guilty? It sounds crazy, right? The consensus among the NACDL is defendants' ability to exercise the right to a fair trial has been undermined in a form of legal coercion in the guise of plea bargains. This sentiment becomes even more obvious when you become familiarized with a concept called the trial penalty. The trial penalty is a phenomenon that's widely accepted by all the major players in the criminal justice system: defendants, prosecutors, defense lawyers, and court employees, as well as judges. It can be defined as the interwoven legal repercussions that are unequivocally imposed upon defendants who choose to invoke their Sixth Amendment right and proceed with their case to a trial by jury. In simpler terms, the trial penalty acknowledges the unknown, steeper risks associated with taking a case to trial, rather than accepting the predetermined and far lesser sentence of a plea bargain. So the following infographic from Pew Research illustrates the confirmable bias of the trial penalty. So you can see here the percent of cases that actually go to trial are 2%, 8% of the cases are dismissed, and 90% of cases choose to plead guilty by way of a plea bargain. Another infographic from Pew Research as well illustrates the drastic decline in the number of cases that are going to trial over a 10-year span. And when you consider the numbers, 80,000 criminal cases are brought to the dockets each year. and only 1,879 of those are going to trial. So, sadly, this data represents the real-life collateral damage that's caused by plea bargaining. One of these cases involves the case of Rodney Roberts. He's pictured here. On May 25th, 1996, Rodney Roberts was arrested and misidentified in a photo lineup. The victim was a 17-year-old female who had been kidnapped and raped, and mistakenly identified Rodney Roberts as her perpetrator. Roberts was charged, but remained insistent upon his innocence. And despite this, upon advice of his attorney, Rodney decided to take a plea bargain. In his own words, Rodney states, "My lawyer said, if you take this deal, they're only offering you 2 years. And if not, they're going to take it off to trial, and the judge is ready to give you a life sentence. If you get found guilty, and I think you're going to get found guilty." Rodney says, "This is my attorney telling me this, the one person I had there to help me." Subsequently, Rodney was sentenced to 7 years in prison. When all was said and done, he served a total of 14 years. It wasn't until the year 2014, 18 years after entering his guilty plea, when Rodney's innocence was proven through the addition of DNA evidence. DNA evidence has helped to point out the fallacies in the swift bargain justice that is the plea bargain. Astonishing data from the Innocence Project drives the point home. In nearly 11% of the nation's 349 DNA exoneration cases, innocent people entered guilty pleas. It becomes increasingly obvious that plea bargaining inherently increases the odds of wrongful convictions. This produces a devastating effect on the lives of not only the person who was wrongfully convicted, but also the victim, who, in the aftermath of the exoneration, learns that the true criminal was never held culpable for the crime. Nonetheless, U.S. Supreme Court rulings have made it easier for prosecutors to exercise unrestricted power in determining the deals that they will offer as leverage against defendants. One such ruling is Broden-Kirker versus Hayes. In the 1978 Supreme Court case ruling, prosecutors may threaten to bring additional charges against defendants who refuse plea bargains, as long as those charges are valid. This ability to manipulate charges gives the prosecution an incredibly heavy bargaining chip to unfairly leverage the plea bargain. A somber example of the ramifications of allowing prosecutors to choose sentencing guidelines is the case of Ray Cromartie. This is a picture of Ray Cromartie. Ray was offered a plea bargain in a murder case, but remained adamant of his innocence. Although very little evidence existed of his guilt, out of retaliation for his refusal to take a plea bargain, the prosecution chose to seek the death sentence in his trial. Because the prosecution fervently rejected all attempts to submit DNA evidence that could exonerate Ray Cromartie, he was sentenced to death and he was executed. Had Ray swallowed his integrity and taken the plea, he could have been paroled after only 7 years. To sum it all up, it becomes glaringly apparent that in the case of plea bargain injustice, Americans facing criminal charges are trapped in a lose-lose paradox. Plea bargaining and consequently the trial penalty are being used as tools of coercion to expedite guilty pleas in an overloaded court system. Many defense lawyers concur that for the defense attorney, there is no more heart-wrenching task than explaining to a client who very likely may be innocent that they must seriously consider pleading guilty. It may be best put by one of our founding fathers: considering the innate right to a fair trial, Thomas Jefferson declares, "I consider trial by jury as the only anchor ever yet imagined by man, by which government can be held to the principles of its Constitution." And so I ask you, can justice truly be served in the era of plea bargaining?